Okay, we are still going through chapter 14 or handout 14, and we're now on the second page, not quite halfway down, where it says the word lapse. At common law, if you made a gift to a beneficiary in a will, and that beneficiary predeceased the testator, the gift to the beneficiary was said to have lapsed. It disappeared. It was treated as if it were passing under the laws of inheritance and would be divided either to the remainder people named in the will or to the heirs at law of the testator. The legislatures of many states about 100 years ago felt that that rule was overly severe, so they passed something called an anti-lapse statute. Both Rhode Island and Massachusetts have these laws, and what these laws say is that if you name a particular person to receive a gift, so if Mary Smith is to receive a gift under your will and Mary dies before you, it doesn't matter. The gift is still made. It will either go to her heirs at law, or if she has a will, it will follow her will and go to her beneficiaries. If you do not want that to happen, then you must, in the will, qualify any gift to a beneficiary, saying that this gift is only if they survive me. And then tell the court what you want to have happen with that gift if the person does not survive you. So if you say nothing beyond that, you make a gift to Mary, Mary dies before you, you are no longer determining what will happen with that gift. Mary's will or Mary's estate will be the deciding factor as to what happens with that asset. The parties who receive something are named in a will or a trust to receive a benefit are called beneficiaries. And in wills, they are divided into two different groups. There are legatees, and legatees are someone who receives a legacy or a gift of personal property. Then there are devisees. These are folks who receive a devise under a will, which is a gift of real estate. All right. Rhode Island also has something called a permitted or omitted heir statute. Very often, in the old days, a father in particular would die while the man's wife was expecting a child. And of course, a child was not born yet. They could not necessarily be named in the will. Sometimes the father would pass away and not even know that the wife was expecting to have a child. So there was a statute passed, and again, both Rhode Island and Massachusetts have adopted this, saying that a child who is left out of a will, if it appears that that is by accident, then that child will be written back in, and they will take whatever they would have received, at least under the laws of inheritance. And in some states, the law even says that they'll be written in to receive equally whatever the other children would have received. They'll be added in as if they had been alive and named in the will. Now, this creates problems if you are trying to deliberately disinherit a child, because there's always the possibility that after you're gone, if your lawyer's gone who helped draw the will and knew what your intentions were, it comes up that one child was not named in the will and the other one or two or three were. The unnamed child could claim that that was by mistake or by neglect. So I have to caution people, if they want to deliberately disinherit a child, we need to actually state in the will that I deliberately choose not to leave anything to my son Fred. Short of that, there's always a possibility that there could be a contest and that Fred could get themselves written back into the will through the probate court. Another thing that we very often put in wills, particularly we think there's going to be a contest, even not by children but by other relatives, is a statement saying that any relative, heir at law of mine, any other person who is not named in this will, that is deliberate on my part, I know, and intentionally only made provisions for the people named herein. Again, stating the intention of the testator that they did not forget, they were conscious of what they were doing, and only the named parties were intended to receive benefits under the last will and testament. At the bottom of page 2 in handout 14, there's a list of statutes that Rhode Island has adopted. And again, remember, the right to make a will is not actually a right. It is a privilege granted to you by the legislature. It is completely controlled by statutes with a little bit of interpretation by the courts, but mostly it is controlled by legislation, and the legislature has traditionally been deemed to be able to change the rules about making wills and what wills mean and how they are to be interpreted at will by passing new legislation. All right, under Rhode Island General Laws 3361, if you leave a gift to a witness of a will, I think we've spoken about this in the last lecture, that gift is void and the will is valid. So the witnessing is valid, but the gift to the witness is not. Contrary to that, if you leave a gift to an executor or a trustee named in a will, that is still a valid gift, and their appointment to those positions is also valid. When a will speaks about real estate, it is presumed that it will apply to whatever real estate the person owned at the time of their death, not the real estate they owned when they wrote the will. So that's an interesting thing, because many people write wills at some point in their life and then go 10, 15, 20 years without ever changing them. But of course, their financial circumstances change. So when in a will it says, I leave my real estate to Joe, that will become any real estate that you own at the time of your death, not whatever real estate you happen to own when you wrote a will. One of the other things that happens that's very difficult at times is that when people specifically name real estate in a will to go to a particular beneficiary, there again, that can create issues, because if they have sold that property and purchased another property, it still may be their intention that the named beneficiary would get whatever property they owned, but if they had specifically named the first property, now that they've sold it, it doesn't exist anymore. And there is no presumption in law that the second property was supposed to follow the same scheme. So we tend to try to discourage people from specifically naming pieces of real estate in their wills, knowing that people buy and sell and change where they live and change what they own fairly frequently in this society. It is something that you have to be aware of when you're dealing with clients, to educate them on this and to make them aware of it. One of the classic examples that I give is that Aunt Louise has a nephew and a niece, and she wants to divide her estate equally between them. And she has a house worth $500,000 on Main Street, and she has $500,000 in CDs, certificates of deposit, in the bank. So in her will, she has her lawyer write a will that says, to my nephew Freddie, I leave my CDs, and to my niece Mary, I leave my house on Main Street. Louise, after a number of years, decides she doesn't want the house on Main Street anymore. It's too big, it's too expensive. So she arranges to sell it, and she's going to look for another house. But in the meantime, she decides to move into an apartment for a while. She takes the $500,000 from the sale of that house and puts them into the bank. And then before she does anything else, she passes away. So we now have a situation where there's $1 million in the bank accounts, and there is no real estate whatsoever. Unfortunately, if Louise had not amended her will or written a new will at this moment, Fred would get everything and Mary would have nothing, because a house at Main Street no longer exists. If the property named specifically in a will does not belong to the testator at the moment of the testator's death, then that gift is null and void. It doesn't happen. It's as if it was never put into the will. All right, 3367 under the Rhode Island General Law says, unless there is clear language to the contrary, a gift of real estate under a will conveys a fee simple absolute to the beneficiary or beneficiaries, or to the devisee, as we call them. Rhode Island General Laws 33611 is our anti-lapse statute, and Rhode Island General Laws 33623 is our omitted child statute. All right. Rhode Island General Law 33633 allows a testator to make gifts to a trust even if the trust has been amended after the will was written. At common law, there were some issues that were brought up by the common law judges, where if a testator had set up a trust and basically said, everything under my estate is to go to my trustee and be handled by my trustee, they imposed some rather severe requirements, saying that the trust had to have been written and in place before the will was created, and basically could not have been amended. That if it was amended, then the gift to the trust was null and void. Based on modern day practice, that is very severe, and as you can see, the legislature took this statute to change that rule. So today, very often we have people who have assets that they want to leave in trust for some reason or another, and we write a will that we actually call a pour-over will, because it pours into the trust, and the will says that anything that wasn't already in my trust when I died, give to my trustee. And it doesn't matter if after they wrote the will, they have amended that trust, they have changed that trust, even they have created a new trust. Under this statute, that is all still valid. We are going to talk about trust quite a bit in handout 15, but for our basic purposes here, it is one of the definitions I put in this section also. A trust is an artificial entity that's created under the law for the purpose of holding legal title to assets. Now, in some ways, it's like a corporation, because like a corporation, it is an artificial reality, an artificial entity. However, unlike a corporation, it does not need any state involvement. To have a valid corporation, you must file paperwork with the state, you must keep that paperwork up every year, you have to pay taxes, you have to do certain reportings to maintain the corporate status and to maintain the corporation as a separate entity. Trusts are entirely private matters until they end up in court for some reason, and as that, it's a very interesting vehicle because it allows parties to set up a private mechanism to hold their property for various reasons, and there is no state involvement, there is no particular court involvement, and with certain types of trusts, it doesn't even make a difference on their taxes. They're allowed to still use their own tax ID number and treat the trust assets and trust income as if it is their personal income. A settlor is a person who sets up or creates the trust. A beneficiary is the person named to receive the beneficial interest of the trust, and the trustee is the person named to administrate the trust and to hold legal title to the property for the benefit of another. We will talk about this at great length in the next handout. Foreign wills. Any will that was drafted and created and probated in a state other than the state where the testator resides is considered a foreign will. Under the full faith and credit clause of the Constitution, the states have to give credit and recognize wills done in another state. So if you were living in California at the time you wrote your will, and it was a valid will under California rules, such as it was a holographic will, which Rhode Island does not generally allow, if that will was valid under California law, and when you die as now a citizen of Rhode Island, that is your only last will and testament, as long as it was valid at the time you executed it in California, Rhode Island must accept it as valid under the California rules. If you own property in more than one state, then you might end up having to open probates in each state where property is located. Now, with financial property, that has become less and less of a problem because all the major banks, all the major stock brokerage companies do not have a particular one-state situs at this point in time. Most of them operate in almost all states across country, so there really isn't an issue with that. But real estate certainly, and certain personal property can become an issue if when you die it is situated in one jurisdiction but you are a resident of another. Generally, your will is first and primarily probated in the state where you die a resident, and then after that, what we call ancillary probate must be opened in each other state where you owned property. An abatement is a situation where there was a specific gift of property, Louise's house on Main Street, named in a will. If that property does not belong to the testator at the time of their death, as we said earlier, the gift is void, and the proper term for that is abated. One of the things that you need to remember when we deal with probate court is that probate court, it does exist to help pass property to the heirs or the beneficiaries, but its primary purpose is to protect creditors. And we'll talk about that a little bit, I believe, in handout 16 when we talk about the probate process. But the reality here is no one gets anything under the will until all the creditors, all the bills that were left by the deceased are paid. And there are priorities, which we'll discuss in another handout. But just remember that reality, that probate court does not exist for the benefit of the family, the spouses, the heirs, the beneficiaries. It is there to ensure the creditors have a vehicle to get whatever is owed to them by the decedent. A number of years ago, about 10 years ago now, Massachusetts decided to amend its 380-year-old probate laws and to adopt something called the Uniform Probate Code. At first, it was rather difficult and confusing because a lot of the Uniform Probate Code does not really mesh with English common law probate issue matters and rules, which is what Rhode Island and Massachusetts had followed up until that time. Rhode Island has not adopted this. We are still using the common law rules. Some of the changes, and there are a multitude of them, and if you're going to be working in Massachusetts, there are several good publications you can buy that kind of lay out these rules and help you step by step figure out how to file documents and get things before the court. One of the interesting things about the Massachusetts probate court is, unlike Rhode Island, where it is very judicial-centered and you end up having hearings to do almost anything, in Rhode Island have to appear before a judge. In Massachusetts, large chunks of the probate process are ministerial. If you file the proper forms, have the proper releases, the proper documents, you never get to see a judge. The clerks are able to handle everything and process everything administratively. Some different things under the Massachusetts statute. Surviving spouses are treated completely differently under the Uniform Probate Code than they are at common law. If no descendants or parents survive the decedent, the surviving spouse takes precedence, 100% preference over brothers and sisters, nephews and nieces, cousins, aunts and uncles of the deceased. Now that is very different from the common law. At the common law, we still followed bloodline, so the spouse would be entitled to a share set by statute of the estate, but the rest of it would go to the deceased spouse's family members, even though they were not children. Now, if all of the decedent's surviving descendants are also descendants of the surviving spouse, and there is no other descendant of the surviving spouse who survives the decedent, that is, if one spouse dies and all of the couple's children are the children of the other spouse, then the surviving spouse takes all. The kids are basically cut out. Now again, this is dramatically different from the common law, dramatically different from what we do in Rhode Island. However, in terms of states like California, Nevada, and Oregon, which are community property states, where the presumption for many years has been that the surviving spouse is an equal co-owner of the property with the deceased spouse, this has been the procedure, and by and large, it's what most people expect. Many times, people, my own clients, have been surprised when their spouse has not bothered to write a will, they haven't bothered to make sure their name gets on the property with the other spouse dies, and they find out that they are now competing with their own children to see who is going to own the property. If there are children of the decedent who are not children of the surviving spouse, then there are formulas, and I've got them in the handout, that basically give some of the property to the spouse and some of the property to the surviving children who are not that spouse's child. Just be aware of that. So at this point in time, the rules are dramatically different, and you need to be aware of this under Massachusetts law, that when you go to even draft a will, you have to know what the underlying rules are so that you can be applying them correctly in the will. I'm going to stop for a minute here.